So the first question is a relationship between international law and municipal law. This is repeated 7 times. So one of the most important questions that might come in the exam. So definition in international law, known as public international law or the law of nations, comprises the body of rules and principles that govern and conduct of sovereign states and other international actors in their interactions with one another. Its primary aim is to regulate global relations, maintain peace, security, foster cooperation, and uphold justice. Whereas municipal law or domestic law or national law refers to the internal legal system of a sovereign state. It governs the legal relationship between individuals within the state as well as between individuals and the state itself. Its scope is confined to territorial boundaries of the state. So the intricate relationship between the two distinct legal orders lies in how international norms and obligations are integrated into or influence a state's domestic legal framework, and conversely how municipal law can sometimes impact the development and interpretation of international law. So there is a lot of synergy between both of them. So basically international law is short lo cheppalante how two countries interact with one another, because every country has their own law. So what to follow ane daniki doubt raakunda, there are some international norms and regulations so that the peace, security, cooperation, justice is maintained. Municipal law is nothing but the domestic law which we have in our country or in any sovereign state. So basically, what they are saying is the relationship ఏంటంటే ఇంటర్నేషనల్ లాకి మున్సిపల్ లాకి సమ్టైమ్స్ ఇంటర్నేషనల్ లా నుంచి మనం కొన్ని తీసుకుని మున్సిపల్ లాలో ఆర్ మన డొమెస్టిక్ నేషనల్ లాలో వాడుకుంటాం. కన్వర్స్లీ నేషనల్ లాలో ఉన్నాయి సమ్టైమ్స్ బికమ్స్ ఇంటర్నేషనల్ లా. సో దెర్ ఈస్ సమ్ సార్ట్ ఆఫ్ సినర్జీ బిట్వీన్ బోత్ ఆఫ్ దెమ్. So what is the theories and explaining the relationship? So the academic discourse on the relationship between international and municipal law have largely been shaped by two classic theories with modern approaches seeking a more pragmatic synthesis. So the two theories on which we can explain the relationship. One is monism. So monism, the core principle is this theory posits that international law and municipal law are not separate but form part of a single unified legal system. They are different manifestations of the same legal order. So the monoism ఏమంటున్నారంటే మున్సిపల్ లా అండ్ ఇంటర్నేషనల్ లా సపరేట్ కాదు, వేరు కాదు, బట్ come from a single unified legal system. They are just different manifestations of the same legal order. So direct applicability ఏంటంటే under a monist view, international law is generally considered to be directly applicable within the domestic legal system without the need for any formal act or transformation or incorporation. Once an international treaty is ratified or a customary international norm is established, it automatically becomes part of the state law. So international law, every international law will become a state law in this theory, monism law. If there is an international law created, then automatically it means the states need not adopt separately, but it becomes a domestic law. Hierarchy in monist theories often propose a hierarchical relationship within international law being supreme over municipal law in case of conflict. This implies that domestic courts would apply international law even if it contradicts a national statute. So hierarchy is international law is on the top. So domestic law or unna.
One of the, sorry to interrupt, but one of the good example of this is India is the party to lot of conventions in the ILO. So party basis kane we fight labor cases in India. So
sometimes my voice
labor
break
cases, the courts have taken. Oh, sorry, I'll shut up then. Okay, go ahead. Sorry.
లేదు చెప్పండి బలవరే, మధ్యలో 2 సెంటెన్స్లు ఎగిరిపోయినాయి అందుకని.
No, quickly I'll tell, so I'll not elaborate ఎందుకంటే సిగ్నల్ పోతుందేమో. బట్ ఏమంటున్నానంటే వన్ ఆఫ్ ద గుడ్ ఎగ్జాంపుల్స్ ఆఫ్ దిస్ ఇస్ ILO కన్వెన్షన్స్ కి ఇండియా ఇస్ పార్టీ టు లాట్ ఆఫ్ కన్వెన్షన్స్ ఇన్ ద ILO, ఇంటర్నేషనల్ లేబర్ ఆర్గనైజేషన్. మనము లేబర్ కేసెస్ ఫైట్ చేసినప్పుడు కోర్ట్స్ రెఫర్ టు దట్ కన్వెన్షన్స్. యాక్చువల్లీ అది reference to international law అనేది courts judgment based on that also will happen in India.
Oh, okay, madam. Good point. Okay. And then proponents. Proponents ఏంటంటే prominent advocates, including Hans Kelsen, who through his pure theory of law viewed international law as a foundational norm from which all other legal systems derive their validity, thus posting its superiority. Next, Hirsch Lauterpacht also leaned towards a monist perspective, emphasizing the individual as the ultimate subject of all law. సో అడ్వకేట్స్, ఈ మోనోయిజం అడ్వకేట్స్ ఇద్దరు ఉన్నారు, హాన్స్ కెల్సన్, హర్ష్ లాటపాక్ట్. సో హాన్స్ కెల్సన్ సేస్ దట్ ప్యూర్ థియరీ ఆఫ్ law viewed internationally as a foundation. So he is saying that international law should be the foundation from which all other legal systems should derive the validity. And Hirsch also leaned towards a monist perspective, emphasizing that individuals as the ultimate subject of all law. So obviously individual is the ultimate subject of all law. ఎవరు లా చేసినా ఇండివిజువల్ మీద పడుతుంది. Anyway, implications ఏంటంటే states adopting a strong monist stance tend to have more unified and integrated legal systems where international obligations are readily enforceable domestically. So since the international law stands on the top, monism లో ఏమవుతుందంటే implication, states adopting a strong monist stand have more unified and integrated legal systems. So dualism ఏంటంటే core principle, dualists agree that international law and municipal law are two entirely separate and independent legal systems. They operate in different spheres, have different subjects and different sources. So what is the transformation and incorporation? For international law to have an effect within the legal system, it requires a specific act of transformation or incorporation by the state's legislature or executive. This typically involves passing domestic legislation that reenacts the international obligation or explicitly incorporates it into the national law. Without such act, international law remains outside the domestic legal sphere and cannot be directly invoked in national courts. So unless the international law is recognized by the domestic law and enacted, the courts cannot directly invoke it in national courts. So then legal validity under the international law unless it is incorporated into the national law. So third one is no automatic superiority. For dualist perspective, there is no superiority of international law or municipal law. If there is a conflict, the domestic courts apply domestic law unless the international norm has been specifically incorporated. The state would then be in violation of international obligations, leading to international responsibility. But the domestic law would still be valid internally. So proponents and leading figures in dualist theory include Heinrich Triepel, who emphasized the distinct will of states as the basis of international law, and Dionisio Anzilotto, who saw international law as resting on the common will of the states. So these people said that international law cannot hierarchy top undadaniki veelledu. Both are different, and international law is something which is resting on the common will of the states. So implications in it, dualist states maintain a clear distinction between the international and domestic legal commitments, often requiring legislative action to implement treaties. Okay, this is the second approach. The third approach is harmonization. Harmonization ఏంటంటే synthetic approach, recognizing the limitations and practical challenges of strict monist or dualist adherence. Many modern legal system scholars adopt a more nuanced approach. This theory acknowledges that the distinct nature of both legal systems but emphasizes the necessity to coexist and function in a coordinated manner. So the third one ఏంటంటే ఇందులో dualist ఏంటంటే state first is basically the monism where international law is on the top. Dualist is both have equal rights, and especially in the nation, domestic laws prevail unless an international laws are taken into consideration by the national law. Third one is harmonization coordination theory, where both the parties, like the international law and the municipal law, recognize the limitations and practical challenges of strict monoist or dualist adherence. Many modern legal system scholars adopt a more nuanced approach, and a practical approach. This theory acknowledges the distinct nature of both legal system, but emphasizes the necessity to coexist and function in a coordinated manner. సో ఏంటంటే ఈక్వల్స్ గా పెట్టుకుని దే హ్యావ్ టు కో ఎగ్జిస్ట్ అండ్ ఫంక్షన్ ఇన్ కోఆర్డినేటెడ్ మేనర్ అని అంటున్నాం అన్నమాట. సో ప్రిజెన్షన్స్ ఆఫ్ హార్మోనీ ఇన్స్టెడ్ ఆఫ్ outright supremacy of strict separation, the domestic this view suggests a presumption that domestic law should, where possible, be interpreted in a way that is consistent with international obligations. Court often strive to avoid creating a conflict between national and international law. Selective incorporation and transformation. States may apply a monist approach to certain types of international law, which is basically which require transformation for others. Example, treaties or customary international law. The third one is judicial discretion and interpretation. This approach allows for greater judicial discretion in how international norms are considered and applied, especially in the absence of conflicting domestic legislation. And the fourth one is focus on compliance. The ultimate goal is to ensure state compliance with international law while respecting the sovereignty and internal legal order of the state. So how is this applicable to India now? So Indian approach to relationship between India and international municipal law is generally considered to be qualified dualism with monoistic tendencies, particularly in realm of customary international law and in interpreting domestic statutes in light of international norms. So constitutional mandate in Article 51C of Indian Constitution is the directive principle of state policy, stating that the state shall foster respect for international law and treaty obligations in the dealings of organized peoples with one another. While not directly enforceable, it serves as a guiding principle for legislative and judicial action. The other one is Article 253, which empowers the Parliament to make any law for implementing any treaty, agreement, or convention with any other country or any decision made at international conference or other body. This article is crucial for legislative incorporation of treaties. Judicial approach. Indian courts generally apply international laws unless it is directly contradicts existing domestic statutes. This judiciary often plays a proactive role in filling legislative gaps by referring to international instruments, especially in human rights cases. So relevant case laws. Basically, there are two case laws. One, Vishaka versus State of Rajasthan. ఇది లాస్ట్ ఇయర్ కూడా మనం చదువుకున్నాము. This is basically how India has incorporated
rules against sexual harassment at workplace కదా.
అవును మేడం. బాబా అసలు మీరు టీచర్ అయితే అసలు లా స్కూల్ పెట్టేసుకుందాం మేడం. ఇవన్నీ ఎందుకు చెప్పండి మనకి ఈ ఊర్లు తిరగటం.
కరెక్టే కదా. యా ట్రూ.
నేను బుక్కులు రాస్తాను, మీరు టీచ్ చేయండి, సరిపోతుంది.
వెరీ గుడ్.
Yeah, okay, sorry. So the case is basically Vishaka versus State of Rajasthan. Banwari Devi, a social worker, was gang raped while preventing child marriage. No existing domestic law addressed sexual harassment at the workplace. The Supreme Court invoked CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women, and laid down binding guidelines on sexual harassment, citing Article 51C. The court affirmed that international conventions can be enforced in domestic law when not inconsistent with fundamental rights and statutory provisions. This marked a pivotal step in India's monist approach, recognizing that utility of international norms in addressing domestic legal voids and reinforcing gender equality. So basically, there were no rules against sexual harassment. So the Supreme Court invoked the Convention on the Elimination of All Forms of Discrimination Against Women, and it quoted Article 51C, saying that they can use laws which are consistent with the national laws, and also which are not inconsistent with fundamental rights and statutory provisions. They can enforce in domestic law. Okay. This marked a pivotal step. I think this is the first time where they said the international law use CHR. Later, I think there were rules that came in for sexual harassment and other domestic issues. So that was the first case in 1997. The second case was Gramophone Company of India Limited versus Birendra Bahur Pandey. Customs authorities seized audio tapes imported from Nepal. The issue was whether an international postal convention applied. The court clarified that international law forms part of Indian law only if not in conflict with domestic statutes. The Supreme Court emphasized that treaties are not automatically enforceable in India unless incorporated by the legislation. However, in the absence of domestic law to the contrary, courts may adopt international conventions to interpret legal action. This case highlights India's qualified dualist approach and reliance on judicial discretion in applying international rules domestically. So a person was sending audio tapes from Nepal, and this was seized because I think audio tapes were not supposed to be sent. But the issue, they said that as per the International Postal Convention, the person had a right to send, like from Nepal to India. So the court had to intervene and they clarified that international law forms part of Indian law only if it is not in conflict with domestic statutes. So if there are domestic statutes, then the domestic statutes prevail. That's what the court emphasized. So first dantlo yes, so second dantlo no. Two cases. Conclusion in India, the interaction between international law and municipal law is governed by the dualist theory in India. While courts increasingly use international law for interpretative guidance, its enforceability depends on domestic incorporation. The balance ensures sovereignty is respected while promoting India's international commitments. So this is all the answer which you have to write for the first question. Okay, any questions? If not, we'll move to the second one. Pawan garu ఒక్కొక్కటి చదువుదాం సార్ మీరు. యా చెప్పండి మేడం. నిర్మలా మ్యామ్.
అదే అది ఇప్పుడు ఇందాక మీరు చదివింది మోనోయిజం, డ్యూయలిజం అవన్నీ కూడా థియరీస్ కిందకి వస్తాయా? వాట్ ఈస్ దట్?
Basically, these are the theories explaining the relationship between international and municipal law.
Done. Got it.
Three theories, మన మోనోయిజము, డ్యూయలిజము, నెక్స్ట్ హార్మోనైజేషన్, కోఆర్డినేషన్ అన్నమాట.
ఓకే.
ఇవి ఎగ్జాంపుల్ ఈ మూడు రాయాలి అండ్ ఈ మూడు రాసి వాట్ ఈస్ అ జ్యుడిషియల్ అప్లికేషన్ ఇన్ ఇండియా. సో ఈ థియరీస్ మనకి ఎట్లా అప్లై అవుతాయి అని దాన్ని మళ్ళీ ఆర్టికల్ 51C ఆఫ్ ఇండియన్ కాన్స్టిట్యూషన్ డైరెక్టివ్ పాలసీ ఆఫ్ స్టేట్ పాలసీ విచ్ సేస్ దట్ ఫాస్టర్ రెస్పెక్ట్ ఇంటర్నేషనల్ లా. ఆర్టికల్ 253 ట్రీటీస్ అగ్రిమెంట్స్ బయట వాళ్ళతో చేసుకునే రెస్పెక్ట్ చేయాలి. సో అవన్నీ కోట్ చేస్తూ మనము డ్యూయలిజమే కానీ మోనోయిస్ట్ టెండెన్సీస్ ఉన్నాయి అంటే మనం కూడా ఇంటర్నేషనల్ లాని కొంచెం రెస్పెక్ట్ చేస్తాం అని చెప్తాం అన్నమాట. సో ఫైనల్ గా దాని తర్వాత ఈ రెండు కేసులు రాస్తాం. ఒకటి మీ కేసు మీకు ఆల్రెడీ తెలుసు. సెకండ్ కేసు ఏంటంటే గ్రామోఫోన్ కంపెనీ కేసు వేర్ దే వర్ సెండింగ్ క్యాసెట్స్ ఫ్రమ్ నేపాల్ టు ఇండియా. అప్పుడు ఏంటంటే గ్రామోఫోన్ దాని మీద చాలా రెస్ట్రిక్షన్స్ ఉండింది మేడం. అప్పుడు వచ్చాయి కదా టేప్స్, ఆడియో టేప్స్, వీడియో టేప్స్ మీద ఇండియాలోకి వస్తే చాలా రెస్ట్రిక్షన్స్ ఉండేవి. బట్ వాళ్ళు ఏంటంటే నేపాల్ వాళ్ళు ఏమన్నారంటే యూ షుడ్ రెస్పెక్ట్ ద ఇంటర్నేషనల్ పోస్టల్ కన్వెన్షన్. ఇఫ్ ఐఎమ్ సెండింగ్ సంథింగ్ ఫ్రమ్ హియర్, మేము పంపించేటప్పుడు మీకు తీసుకోవడానికి ప్రాబ్లం ఏంటి? Then the Supreme Court said, "Ala dabadu domestic statutes apply in India. If there are rules in India, then the rules first ma rules prevail avute. Tarvata we'll respect the international rules." So rendu cases rayalanamata.
Okay, done. Got it. Thank you. Thanks for the summarization.
Yeah.
So this is more or less like India treated sending those gramophones or importing is like smuggling.
Correct, sir. Customs and అంతే కదా సార్, స్మగ్లింగ్.
అంతే.
ఓకే సార్. సార్ సెకండ్ మీరు చదువుతారా?
Fine sir.
I'll quickly grab something to eat. I'll be here. Yeah. Thank you sir. Thanks.
Okay, I'll start. Law of the sea, evolution, UN convention, continental shelf, exclusive economic zone, high seas, territorial waters, contiguous zone, maritime states jurisdiction. Basically this is about law on sea. So different way lo idu adugochu. What are the evolution of law of the sea ani, what are the conventions related to law of the sea or territorial water gurinchi atlanti. So this is repeated 6 times. One of the important question we can treat. So the law of the sea is a crucial area of international law that governs the rights and duties of states in maritime environments. It's a complex framework designed to manage the world's oceans and their resources, balancing the interest of coastal states with the freedom essential for global commerce and exploration. Evolution of law of the seas. Historically, the oceans beyond a narrow band of territorial waters were largely governed by the freedom of the seas doctrine. So there is a doctrine by name freedom of the seas. So it is started from there. This meant open access for all nations for navigation, fishing, and other activities. However, increasing resource exploitation and technological advancement necessitated a more structured legal regime. The first major attempt at codification occurred with the 1958 Geneva Convention on the Law of the Sea. So the first codification happened with Geneva Convention in 1958, which consisted of 4 separate conventions. While significant, these conventions didn't fully resolve all issues and left many ambiguities. The modern framework was largely established by the Comprehensive United Nations Convention on the Law of Seas, adopted in 1982 and coming into force in 1994, often called the Constitution for the Oceans. First one was the Law of the Sea, and this is called the Constitution for the Oceans. UNCLOS replaced the Geneva Convention, establishing a delicate balance between expanded rights of coastal states over adjacent waters and the traditional freedoms of navigation and overflight for all nations. It is a foundational treaty for contemporary maritime governance. So this has first one is 1958 Geneva Convention, and second one is Constitution for the Ocean in 1982, but came into force in 1994. But it has more importance. Second one, zones under UNCLOS. UNCLOS meticulously defines various maritime zones, each with specific rights and responsibilities for coastal states and other international actors. Territorial waters up to 12 nautical miles from the baseline. A coastal state exercises full sovereignty over this zone, including the airspace above it and the seabed below. So up to 12 nautical miles వరకు full sovereignty అంటే ఆ country rules ఏమేమి ఉన్నాయో all those are applicable, and within bed of the sea or above the sea, like ocean also. The sovereignty is subject only to the right of innocent passage for foreign vessels, meaning passage that is not prejudicial to the peace, good order, or security of the coastal state. So, the sovereignty is subject only to the right of innocent passage for foreign vessels. బట్ ఇక్కడికి వచ్చేసరికి అంటే మన ఫిషర్మెన్స్ చాలా వరకు ఐ థింక్ దే విల్ ఈ టెరిటోరియల్ వాటర్స్ లో ఎంటర్ కాగానే వాళ్ళని పట్టుకుంటారు కదా చాలాసార్లు. సమ్ ambiguity about it. Contiguous zones 12 to 24 nautical miles from the baseline. In this zone, the coastal state has limited powers. It can exercise the necessary control to prevent or punish violations of its customs, physical immigration, or sanitary laws committed within its territorial waters or territory. So it does not confer full sovereignty. So first 12 nautical miles ki full sovereignty, 12 to 24 is contiguous zone. So exclusive economic zone up to 200 nautical miles from the baseline. With its exclusive economic zone, a coastal state has the sovereign rights for exploring, exploiting, conserving, and managing all natural resources, whether living or non-living, found in the waters on the seabed and in the subsoil. So ఏదైనా ఆయిల్ ఎక్స్ప్లోరేషన్ ఏదైనా అయినా కూడా దిస్ కమ్స్ అండర్ ఎక్స్క్లూజివ్ ఎకనామిక్ జోన్ విచ్ ఇస్ అప్ టు 200 nautical miles. Crucially, other states retain the fundamental freedoms of navigation and overflight within EEZ, as well as the freedom to lay submarine cables and pipelines, but not for exploration. So continental shelf up to 200 nautical miles from the baseline, potentially extending further. This refers to the seabed and subsoil of the submarine areas that extend beyond a state's territorial sea throughout the natural prolongation of its land territory. Coastal states have sovereign rights over the natural resources, mineral and other non-living resources of the seabed and subsoil, together with living organisms belonging to sedentary species of their continental shelf. These rights are exclusive in the sense that if the coastal state does not explore or exploit the resources, no one else may undertake these activities without its express consent. High seas beyond EEZ. The high seas are open to all states, whether coastal or landlocked. They are characterized by the principle freedom of the high seas, which includes freedom of navigation, fishing, overflight, scientific research, and the laying of submarine cables and pipelines. Article 87 UNCLOS. No state can validly purport to subject any part of the high seas to its sovereignty. So, in snippet summary and UNCLOS Constitution for the Ocean, when they have United Nations Convention, they have codified it. They have divided zones. One is first part is territorial waters up to 12 nautical miles from the coast, and contiguous zone 12 to 24. The territorial waters is full sovereignty, and contiguous zone limited sovereignty. Exclusive economic zone for exploration of oil, those kind of things. This is exclusive economic zone. Continental shelf, again it is same EEZ only, more or less. And next is high seas, which is beyond their limit. So these are the 5 levels. Maritime states jurisdiction. Coastal states primarily exercise jurisdiction within the territorial sea. So only first part they get full sovereignty. So they can have states jurisdiction. And their exclusive economic zone. The contiguous zone grants limited enforcement powers. So here the contiguous zone and exclusive economic zone up to 200 nautical miles only. Okay, let's move further. Yeah, given the vastness and shared nature of the oceans, disputes frequently arise concerning fisheries, navigation rights, environmental protection, and most commonly maritime boundary delimitation. UNCLOS provides the mechanism for peaceful dispute resolution, including submission to the International Tribunal for the Law of the Sea of the International Court of Justice. So, a dispute situation, they can it can be forwarded submission to International Tribunal. So,
Sir,
relevant case laws, Anglo-Norwegian fisheries case.
Sir,
Yes.
sir, before going
sir,
to before going into the case laws, if we recollect it once again, it will be good, I think.
అదే సార్ సమ్మరీ కింద నేను మళ్ళీ ఆ 5 points మళ్ళీ చెప్పాను కదా, దట్స్ వాట్.
Okay.
So zones లో there are 5 zones they have divided. I mean there are basically 2 treaties. One is 1958 Geneva Convention. This is the first law of the sea, and second is in 1982 United Nations Convention on the Law of the Sea. This is called as a Constitution for the Oceans, which is enforced in 1994. This divided zones into 5 parts. One is first territorial waters with full sovereignty up to 12 nautical miles. Then second is contiguous zone 12 to 24 nautical miles from the baseline. Third is exclusive economic zone. So up to this area, 200 nautical miles, countries can explore for oil, those kind of things, and any seabed exploration, etc. Continental shelf up to this again same 200 nautical mile, and potentially extending further if needed. And the 5th one is high seas. So this is open to everybody. High seas is that's beyond 200 nautical miles.
Yes, sir. Yes, sir.
So that is the summary. And states maritime states jurisdiction, that is same, it is covered. Territorial sea part 1 lo vachesarki they get full rights. and exclusive economic zone kochesarki they have limited rights, and but they will not allow any other countries to do any exploration in their territory. But beyond that, it is high seas for which is for everybody, for navigation, all those things. Okay. And if there is any dispute, that can be given to International Tribunal and International Court of Justice.
Yes, sir.
Okay. I'll move to relevant case laws.
Yes, sir.
Anglo-Norwegian fisheries case, UK versus Norway. The UK challenged Norway's trade baseline method for delimiting its territorial waters due to its deeply indented coastline affecting fishing rights. This is the issue. Ruling is ICJ upheld Norway's method, recognizing that unique geographical features could justify a non-traditional baseline system, provided it was reasonable and consistent with general international law. It emphasized the relevance of historic title and consistent state practice in delimiting maritime zones. Significance: this case was foundational in legitimating the use of straight baselines for complex coastlines, reflecting flexibility in interpreting maritime sovereignty and influencing the latter provisions in UNCLOS. And second case, ఒకసారి కేస్ స్టడీస్ రెండు చదివిన తర్వాత వేణు సార్ will explain, because this needs some summary kind of thing. MV Saiga case, Saint Vincent versus Guiana. Issue: Guiana seized an oil tanker registered in Saint Vincent outside its territorial waters for alleged smuggling. So beyond their territorial waters, they seized this oil tanker. Ruling: the International Tribunal for the Law of the Seas declared the seizure is illegal. It affirmed that Guiana had no enforcement rights beyond its territorial sea in this context, except where specifically empowered by international law, hard pursuit within the contiguous zone for specific violation. The tribunal reinforced the freedom of navigation, Article 87 UNCLOS, and stressed that custom and enforcement powers in the contiguous zone are limited to prevention and punishment of violation within the territory or territorial sea. అంటే బియాండ్ యువర్ టెరిటోరియల్ సీ కంటిజియస్ జోన్లోకి వచ్చేసరికి దే డు నాట్ హ్యావ్ ద సీజింగ్ పవర్ అని చెప్పి దట్స్ వాట్ ICJ said, International Tribunal said. Significance: this case strongly reinforced flag state jurisdiction and clarified the limitation on coastal state enforcement powers in maritime zones beyond the territorial sea, particularly in the contiguous zone, emphasizing adherence to the precise provisions of UNCLOS. అంటే వీళ్ళ టెరిటోరియల్ సీట్స్ దాటేసి ఈ కంటిజియస్ జోన్ లో వచ్చేసి ఫ్రీ నావిగేషన్ ఉండాలి, దే కెనాట్ సీజ్ అని చెప్పి ఇంటర్నేషనల్ ట్రిబ్యునల్ సెడ్. వేణు సార్, anything on these two cases you want to add?
Yeah.
ఫస్ట్ కేస్ అర్థం కాలేదు సార్.
యా సార్, బెస్ట్ ఏంటంటే నేను ఒక పని చేస్తాను. ఐ విల్ షో యూ మ్యాప్. కెన్ యూ సీ ద మ్యాప్?
Yes.
సో బేసికలీ ఏంటంటే దాన్ని ఎక్స్ప్లెయిన్ చేయడం కష్టం. సో ఇన్ ద మ్యాప్ ఇఫ్ యూ సీ వాట్ ద నార్వే సేస్ ఈస్ ద మ్యారిటైమ్ బౌండరీ ఏదైతే రెండు స్టేట్స్కి ఉందో దట్ వాజ్ ఆన్ డిస్ప్యూట్ సార్. ఓకే, సో నార్వే ఏమందంటే స్ట్రైట్ లైన్ మెథడ్ యూజ్ చేసి ఇక్కడ డాట్స్ కనపడుతున్నాయి కదా, ఈ రైట్ సైడ్ యునైటెడ్ కింగ్డమ్ వాస్ క్లెయిమింగ్, బట్ నార్వే సైడ్ విల్ యూజ్ ఎ స్ట్రైట్ లైన్ మెథడ్, ఓకే, and draw the boundary like this. Adhamaina sir?
Yes.
Now it is easy to understand what they are saying. Okay. So the UK challenged Norway's straight line baseline method. ఇప్పుడు అర్థమైంది కదా, ఫర్ డీలిమిటింగ్ ఇట్ టెరిటోరియల్ వాటర్స్. సో నాకు కూడా ఏంటంటే ఆ బొమ్మ చూస్తే దాకా అర్థం కాలేదు ఇది ఏం రాస్తున్నాడు రైడ్. సో
యూకే వెళ్ళి అంటే బియాండ్ అంటే
యునైటెడ్ కింగ్డమ్ అండ్ నార్వే హ్యావ్ ఏ బార్డర్ కదా సార్, ఇందాక మీకు చూపించినట్టు. దిస్ ఈస్ యునైటెడ్ కింగ్డమ్, దిస్ ఈస్ నార్వే సార్. సో మ్యారిటైమ్
స్ట్రైట్ లైన్ మెథడ్ ఇది స్ట్రైట్ గా ఉండాలని నార్వే అంటుంది, యూకే సేస్
ఎందుకంటే ఇక్కడ ఫిషింగ్ వి ఎక్కువ ఉంటాయి, ఇక్కడ ఫిషింగ్ వాళ్ళు So why will they claim అక్కడ fish ఎక్కువ పట్టడం? Something is happening there, right? So the UK says నేను ఇలా ఫాలో అవుతానని, whereas the Norway says ఒక straight line గీయండి అంటున్నారు. So straight line base claim and then implied maritime limit and maritime boundaries. Okay.
Perfect, sir. Second అయితే straightforward ఉంది. You want to add anything in second case?
Second is basically the same, where Guyana seized an oil tanker which is registered to Saint Vincent outside its territorial waters for illegal smuggling. So basically Guyana is in where is Guyana? It's in Africa, right? So Saint Vincent వాళ్ళు ఏంటంటే okay, whatever said and done, but that is not a territorial water. Okay, so then it is illegal. So నువ్వు వాడు ఏమన్నా చేయండి, నువ్వు why did you go and pursue him outside your limits? So the case strongly reinforced flag state jurisdiction and clarified limitations on the coastal state enforcing powers. Vaadu Saint Vincent is a small, it's a Caribbean country. So Guyana వాడు షిప్ ని చేసి నువ్వు స్మగ్లింగ్ చేస్తావు, వాడు స్మగ్లింగ్ చేసి ఏమైనా చేస్తావు, కానీ నీ టెరిటరీలో లేడు వాడు.
Right. So beyond your sovereignty.
Exactly. That's what is the case.
Okay.
ఇప్పుడు ఓవరాల్ గా 1224,200 nautical miles.
Yeah, sir. 1224,200. Yes.
ఇది కూడా ఏంటంటే not to waste anybody's time, but I'll show you for Sri Lanka how it is. Can you see it?
Yes.
So if you can clearly see territorial, contiguous, మనం నేర్చుకున్నాం కదా సార్ అన్ని, and this is the exclusive economic zone. So this is what is Sri Lanka's. Okay, sir?
Okay.
Sorry, మీకు ఈరోజు బొమ్మలు ఎక్కువ చూపిస్తున్నాను.
No, sir, it is easy to understand now.
ఇది అంత రాయటం కన్నా అది మనం దాన్ని రాయొచ్చు.
True. Okay.
So anyway, sorry. Go ahead, Pawan garu, if you don't mind.
I'll go to conclusion.
Yeah.
I'll go to conclusion. The law of the sea, as comprehensively codified in UNCLOS, represents a monumental achievement in international cooperation. It successfully navigates the complex balance between sovereign rights of coastal states over their adjacent waters and resources, and the essential freedoms of navigation and communication vital for global commerce and peace. The evolution from the freedom of the seas doctrine to the structured regime of UNCLOS demonstrates the international community commitments to orderly conduct and sustainable management of world's oceans. While disputes inevitably arise, the framework provided by UNCLOS and its dispute resolution mechanism offer crucial avenues for peaceful resolution, ensuring the continued viability and shared benefit of these vital global commons. So because of these divisions, it can be, if there is any dispute arises, they can peacefully solve these issues. And that's what conclusion says. With that, we will complete question number 2. Question number 3. I'll read question number 3, sir. Then you can start.
Yeah. Thank you, sir. Thank you.
United Nations Organization, UNO, Constitution, functions, powers, UN Charter, General Assembly, purpose and principle. This is repeated 4 times, so they can ask what are UNO constitutions or what are UNO purpose and principles, write about UN Charter, functions and UN powers, those kind of things. So the United Nations Organization stands as the foremost international body dedicated to fostering global peace, security and cooperation. Born from the ashes of World War II, its foundational principle and structure aim to prevent future conflicts and address shared global challenges. So we all know after World War II, so all countries came together and formed the United Nations Organization to for the purpose of peace, security and cooperation between all the countries. So constitution and structure of the UN, establishment and founding document. The UN was formally established on 24th October 1945 following the ratification of its founding treaty, the UN Charter, by the majority of its 51 original member states The charter was signed in San Francisco, making a pivotal movement in international relations. The organization's headquarters are located in New York City. Main organs, Article 7 of the UN Charter. The UN operates through 6 principal organs, each with distinct functions to uphold Charter's objectives. First one is General Assembly, the main deliberative, policy making and representative organ. This mainly works for peacekeeping. A Security Council, primarily responsible for maintaining international peace and security. Economic and Social Council coordinates the economic, social, and related work of the UN and its specialized agencies. International Court of Justice, the principal judicial organ of the UN. Secretariat, the UN administrative arm, headed by the Secretary General. Trusteeship Council, originally established to supervise trust territories. It suspended operations in 1994 after its last trust territory gained independence. While formally existing, it is currently inactive. The sixth one is inactive. So purposes and principles, Article 1 and 2 of UN Charter. The UN Charter clearly outlines the core objectives and guiding principles that underpin the organization existence and activities. Article 1, purposes: maintain international peace and security. This is the paramount purpose, involving collective measures for the prevention and removal of threats to peace, and for the suppression of acts of aggression or other breaches of the peace. Develop friendly relation among nations based on respect for the principle of equal rights and self-determination of people. Achieve international cooperation in solving international problems of economic, social, cultural, or humanitarian charter, and in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. Be a center for harmonizing the action of nations in the attainment of these common ends. And that's about purposes. Principles in Article 2, sovereign equality of all its members. Each state is equal in rights and duties regardless of seizures of power. The fulfillment of obligation in good faith. All members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfill in good faith obligation assumed by them in accordance with the present charter. Peaceful settlement of international disputes. Members shall settle their international disputes peacefully, means in such a manner that international peace and security and justice are not endangered. Prohibition on the threat or use of force. All members shall refrain in their international relations from the threat or use of force against the territory integrity or political independence of any state, or in any other manner inconsistent with purpose of United Nations, except for in self-defense or under Chapter 7, authorization by the Security Council. Assistance to the UN. All members shall give the United Nations every assistance in any action it takes in accordance with the present charter, and shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. Non-intervention in domestic matters. The UN shall not intervene in matters which are essentially within the domestic jurisdiction of any state. So, though the principle does not prejudice the application of enforcement measures under Chapter 7. So, ఇప్పటి వరకు ఉన్న సమ్మరీ ఏంటంటే structure of the UN, it is basically 6 charters are there, which include General Assembly, Security Council, Economic and Social Council, International Court of Justice, Secretariat. The last one, Trusteeship Council, which is not active now. So purpose and principles are mentioned in Article 1. Principles are mentioned in Article 2. Purpose is basically maintain international peace, develop friendly relation, and international cooperation. Sovereign principles are sovereign equality, peaceful settlement of any disputes are there, and prohibition of threat for any or use of force on any country. చిన్న కంట్రీస్ పైన పెద్ద కంట్రీస్ వార్ చేయకుండా అట్లా ప్రొహిబిషన్ అసిస్టెన్స్ every country has to assist to UN, and UN should not intervene in any domestic matters. So next about that's about purpose and principles. Now we will talk about other charters. General Assembly, Security Council. General Assembly is the UN main deliberative body, often referred to as the Parliament of Nations. Composition: it comprises of all 193 member states, each having one vote regardless of size or influence. Functions: discuss and make recommendations on wide range of international issues, except those currently under consideration by the Security Council. Approve the UN budget and assess the member contribution. Elect non-permanent members of the Security Council, members of ECO, SOC, and judges of the ICJ. Initiate studies and make recommendations for promoting international cooperation in the political, economic, social, cultural, education, and health fields. Promote the progressive development of international law and its codification. Voting resolution requires either a simple majority or a two-third majority for important questions. Example: peace, security, admission, new member. GA resolution are generally non-binding or member states functioning more as a recommendation that carries significant moral and political authority. So this is about General Assembly. It contains all 193 states, each one having one vote, and it functions are basically elect non-permanent members of Security Council, approve the UN budget, ICJ, appointing ICJ judges, promote the progressive development of international law. These are the things. So they all has voting, but end of the day, beyond their voting, there is something called veto power. I think that is not mentioned here. If everybody votes for something, and these veto countries can come and say no to it. Then Security Council. Security Council holds the primary responsibility for maintaining international peace and security, making its decision legally binding on member states. Composition: it consists 15 members, 5 permanent members, China, France, Russian Federation, the United Kingdom, and the United States. Each P5 member possesses the controversial veto power, meaning a single no vote from any P5 member can block a substantive resolution regardless of the number of affirmative votes. 10 non-permanent members elected by the General Assembly for 2-year terms, with 5 being repeated each year. Geographical distribution is a key consideration in the re-election. So 5 permanent members, as I mentioned just now, veto power, and there are 10 non-permanent members are elected, and their responsibility for maintaining international peace and security. Primary responsibility and powers: investigate any dispute or situation which might lead to international friction, recommend methods of adjusting such disputes or the terms of settlement, formulate plans for the establishment of the existence of a threat to the peace, breach of the peace, or act of aggression. Take enforcement measures under Chapter 7 of the UN Charter, which can range from imposing sanctions, economic sanctions, or arms embargoes, to authorizing the use of force, military action, peacekeeping operation to restore international peace and security. These Chapter 7 decisions are binding on all member states. So these are the primary responsibility and responsibilities and powers of Security Council. Basically, again, international security and international peace. And other principal organs: Economic Social Council, ECO, SOC, composed of 54 members elected by the General Assembly for 3-year terms. So General Assembly lo 193 countries that will select Economic and Social Council countries, 54 members. It serves as the central platform for discussion and policy making on economic, social, and environmental issues, coordinating the work of UN numerous specialized agencies, funds, and programs like such as WHO, UNICEF, UNDP. Secretariat, the other organ, the UN administrative and executive arm responsible for the day-to-day work of the organization. It is headed by Secretary General, who is the Chief Administrative Officer and a prominent diplomatic figure. The Secretariat carries out the diverse mandates of the UN, from preparing reports and studies to organizing conferences and managing peacekeeping operations. International Court of Justice (ICJ), located in The Hague, Netherlands, the ICJ is the principal judicial organ of the UN. It settles legal disputes between states and gives advisory opinions on legal questions referred to it by authorized UN organs and specialized agencies. Its judgments in contentious cases are binding on the states involved. So, after talking about the principles and powers, we discussed about General Assembly, Security Council, and apart from that, other organs are Economic and Social Council, Secretariat, and ICJ. This is about summary. So, shall I move to case laws?
Yeah, sir. Yeah.
Relevant case laws. Admission of a state to the United Nations Advisory Opinion, ICJ reports, 1948. Okay. So now we are moving out of Supreme Court or High Court. Issues. The General Assembly sought clarification on whether the admission of a state required recommendation from the Security Council under Article 4 of the UN Charter. Ruling. The ICJ advised that admission was a two-tied process. A positive recommendation from the Security Council is a necessary condition, for the General Assembly to the admitted state. The court stressed that criteria for admission, peace-loving acceptance of charter obligation must be adhered to, and political consideration should not override legal requirements. Significance. This advisory opinion reinforced the procedural integrity of the UN Charter, particularly the distinct but interdependent roles of the Security Council and General Assembly in admission process. Indonesian withdrawals from the UN. Context. In 1965, Indonesia announced its temporary withdrawal from the UN in protest against Malaysia's election to the Security Council. The UN Charter does not explicitly provide for a right of withdrawal. Outcome. After about a year, Indonesia resumed its full participation in the UN, effectively by simply reactivating its presence without requiring a formal readmission process or the procedures for a new member state. Significance. This president established the understanding that withdrawal from the UN is not legally recognized under the Charter. Membership is considered effectively permanent unless a state is formally suspended or expelled. A rare extreme measure under Article 6 of Charter. It highlighted the inherent presumption of continuous membership and the political rather than legal nature of such absence. So Malaysia, when Malaysia was elected to UN as a member state, Indonesia కోపొచ్చి we don't accept it అని చెప్పి 1 year వాళ్ళు దూరంగా వెళ్ళిపోయారు. Then they came back again. That's it. Anything you want to add, Venus?
Nothing much, sir. Basically, United Nations గురించి every year అడుగుతున్నారు question. So, United Nations basically, what are the purposes? Why was it set up in 1945? What are the purposes? What are the principles on which it stands? The two key things ఏంటంటే ఒకటి ఆ General Assembly ఉంది, which has 193 members, and the Security Council, which is an important, powerful council where everybody wants to get in as a permanent member, but there are only 5 permanent members and 10 of them are non-permanent, and they keep rotating every 2 years. So that is one of the key things. And then there are other principal organs, I think UNDP and other areas we have studied in last semester, and Economics and Social Council, ECOSOC, and the Secretariat, the Secretary General, ఎవరైతే ఉంటారో. అండ్ ద అదర్ థింగ్ ఇంటర్నేషనల్ కోర్ట్ ఆఫ్ జస్టిస్. ఇప్పుడు రీసెంట్గా ఏదైతే ఇండస్ వాటర్స్ గురించి ఇంటర్నేషనల్ కోర్ట్ ఆఫ్ జస్టిస్కి వెళ్ళి వీళ్ళు ఫైట్ చేద్దాం అనుకుంటున్నారు పాకిస్తాన్ వాళ్ళు. సో ఇప్పుడు అడియర్ చేయకపోతే యుఎన్ శాంక్షన్స్ పెడతారనమాట. And the relevant, see, basically United Nations, there is nothing relevant. కేస్ లాస్ ఇక్కడ ఏం పెట్టాలి అన్నప్పుడు వి జస్ట్ థాట్ వాట్ ఈస్ అడ్మిషన్ ఆఫ్ స్టేట్ అంటే యునైటెడ్ నేషన్స్ లోకి డైరెక్ట్ గా కెన్ ఎనీ కంట్రీ జస్ట్ సే ఓకే ఐ వాంట్ బి పార్ట్ ఆఫ్ యుఎన్. సో యునైటెడ్ నేషన్స్ ఏంటంటే దే గేవ్ సమ్ క్లారిఫికేషన్ సేయింగ్ దట్ ఎనీ న్యూ స్టేట్ ఎవరైనా ఎంటర్ కావాలంటే సెక్యూరిటీ కౌన్సిల్ రికమెండేషన్ ఫస్ట్ ఇవ్వాలి. 2-tier ప్రాసెస్ అనమాట. అండ్ దెన్ జనరల్ అసెంబ్లీలో అడ్మిట్ చేసి తీసుకుంటాము అని చెప్పారనమాట. సో అందులో ఒక సింపుల్ ఏంటంటే యునైటెడ్ నేషన్స్ ఇండోనేషియా వాళ్ళకి మీరు అన్నట్టు ఇందాక 1965లో కోపం వచ్చి మలేషియాకి ఎందుకు ఇచ్చారు, మేము వెళ్ళిపోతాము సెక్యూరిటీ కౌన్సిల్లోకి ఇచ్చారు, అప్పుడు 2 years ఇస్తారు కదా, అది ఎందుకు ఇచ్చారని వీళ్ళు వెళ్ళిపోయారు. బట్ ఆఫ్టర్ దట్ ఆఫ్టర్ 1 year దే కేమ్ బ్యాక్, బట్ దే డి నాట్ హ్యావ్ టు గో త్రూ ద procedure of all the 2-tier process. Indonesia resumed its full participation effectively by simply reactivating its presence without requiring a formal readmission process of procedures for the new member state. సో ఒకసారి మెంబర్ అయితే మళ్ళీ అలిగినా కానీ మళ్ళీ నీకు అంత పెద్ద ప్రాసెస్ ఉండదు, ఇమ్మీడియట్ గా మళ్ళీ జాయిన్ అవ్వచ్చు అన్నమాట. అది సార్ దట్ వాస్
ఫస్ట్ కేసులో వచ్చేసి 2-tier ప్రాసెస్ అంటే లెట్స్ అజ్యూమ్ అంటే ఇప్పుడు యుఎస్ఎస్ఆర్ డివైడ్ అయినప్పుడు యుక్రెయిన్, కజకిస్తాన్ ఇట్లాంటివన్నీ అయినాయి. ఫర్ దెమ్ దీస్ 15 members of Security Council has to recommend for them to join. Then only they can be accepted, right?
కరెక్ట్. అంటే ఇప్పుడు ప్రస్తుతంలో న్యూ కంట్రీస్ ఏం ఫామ్ కాలేదు కదా సార్. లైక్ బంగ్లాదేశ్ ఉంది అనుకోండి. Bangladesh, how did it get into UN is first so Security Council has to accept it that is a separate country, because there will be Pakistan will be pushing it saying that it is part of us, you don't need to recognize as a second country, right? So adi okati untadi. And the second thing, General Assembly lo evaru vallu favor unnaru, broadly all peace loving unnara, acceptance by other charter obligations unnaya, ivanni unte manam teesukundam anukuntaru.
Ante. So all these 15 Security Council members has to recommend first thing, and మీరు అన్నట్టు ఇప్పుడు పీస్ లవింగ్ యాక్సెప్టెన్స్ చార్టర్ అప్లికేషన్స్ ఇవన్నీ ఉంటేనే దెన్ యుఎన్ కెన్ అడ్మిట్ దట్ కంట్రీ.
సో 15 members and 5 members వీటో చేసే పవర్ ఉంటుంది కదా సార్. సో 5 ఓకే అంటేనే సెక్యూరిటీ కౌన్సిల్లో యాక్సెప్ట్ అవుతుంది. సో బేసికలీ ఫస్ట్ వన్ ఇస్ నాట్ ఎ కేస్, ఇట్ ఈస్ జస్ట్ అడ్మిషన్ ఆఫ్ స్టేట్ టు ద యునైటెడ్ నేషన్స్.
వాట్ ఈస్ ద ప్రాసెస్? ఇది కేసు లా కన్నా ఎక్కువ ఏంటంటే ప్రాసెస్ టు అడ్మిట్ ఏ కంట్రీ ఇంటూ.
సెకండ్ వన్ ఇస్ జస్ట్ ఇండోనేషియా ఇస్ జస్ట్
సో కంక్లూజన్ వచ్చేసి ఎస్ చెప్పండి సార్.
ఈ యుఎన్ఓ ఇస్ యాక్టింగ్ ఎఫెక్టివ్లీ సార్. అసలు ఎఫెక్టివ్ గా ఉంటే వార్స్ ఎందుకు వస్తున్నాయి అసలు?
That is out of syllabus, sir.
And just for our knowledge sake, I'm asking.
Tiger without teeth. UNO has become a tiger without teeth.
Well said, madam. Well said. Well said. If it is affecting properly, ఇవన్నీ ఇప్పుడున్న ఇవన్నీ అసలు జరిగే కాదేమో నాకు తెలిసి.
జరిగేది కాదు. యుఎస్ కాన్స్టెంట్లీ సేస్ నేను విత్డ్రా అవుతాను కాంట్రిబ్యూషన్. యుఎస్ హ్యాస్ టు గివ్ సర్టెన్ అమౌంట్ ఆఫ్ కాంట్రిబ్యూషన్ టు రన్ యునైటెడ్ నేషన్స్ ఎవ్రీ ఇయర్ ప్రతి కంట్రీ ఇవ్వాలి. యుఎస్ ఇస్ ద సింగిల్ లార్జెస్ట్ కాంట్రిబ్యూటర్. వాడు ఒకసారి నేను ఇస్తానంటాడు, ఒకసారి ఇవ్వనంటాడు, డ్యూస్ పెడతాడు, ఏమి ఎవరు మాట్లాడలేరు. ఇట్ హస్ బికమ్ ఏ జోక్ ఆర్గనైజేషన్ నౌ.
మేడం మీరు అన్నట్టు అవుట్ ఆఫ్ సిలబస్ టైం వేస్ట్ అవుతుంది, కానీ లాస్ట్ టైం మన బుష్ ఉన్నప్పుడు ఇట్లాగే ఒకసారి అన్నారు తెలుసా, మీరందరూ కాలగర్భంలో కలిసిపోతాడు అన్నాడు. మీకు గుర్తుందో లేదో? యుఎన్ఓని వీళ్ళని వాళ్ళు చెప్పింది వినలేదని.
ఓకే, ఒక కామెంట్ ఏంటంటే వాళ్ళు డిఫైన్ చేసిన ప్రాసెస్ ఫాలో అవుతున్నారు. ప్రాబ్లం ఎక్కడ వచ్చిందంటే ఆ పర్మనెంట్ మెంబర్స్ వీటో పవర్. సో ఆ బేసికలీ ఆ 5 ఓకే అవుతే పర్మనెంట్ ఆటోమేటికల్లీ అది ఓకే అవుతుంది జనరల్ గా. అన్ఫార్చునేట్ గా 5 ఎప్పుడు ఒక దగ్గర వీటో పవర్ ని వాడుతున్నారు.
అందుకనే ఇట్ ఈస్ డిజాల్వింగ్ అన్నమాట.
అంతే
ఉంది కానీ మీరు అన్నట్టు మేడం చెప్పినట్టు లైన్ వితౌట్ టీత్.
లైన్ వితౌట్ టీత్. యా, అక్కడ మెయిన్ వీటో పవర్ మెయిన్ ప్రాబ్లం అక్కడ. ఫర్ ఎగ్జాంపుల్ ఇప్పుడు పాలస్తీనాకి ఇప్పుడు సెప్టెంబర్లో జరిగే జనరల్ అసెంబ్లీలో మోస్ట్ ఆఫ్ ద కంట్రీస్ ఆర్ రెడీ టు యాక్సెప్ట్ ఫర్ పాలస్తీనా. సో బట్ యునైటెడ్ నేషన్ ఈజ్ నాట్ రెడీ. సో వీళ్ళు ఎంతవరకు ఏదనుకున్నా జస్ట్ సపోర్టింగ్ స్టేట్మెంట్ వరకే అవుతుంది, కానీ అది కావాలంటే వీడు ఎట్లా చేసేవాడు ఓకే అన్నాడు. ఇప్పుడు మనం పాకిస్తాన్కి ఏదైనా అపోజిట్ అంటే చైనా వాడు అడ్డం వస్తాడు ఇట్లా. సో ఆ ఐదుగురు ఆడుకుంటున్నట్టు బేసికలీ చెప్పాలంటే. ఆ ఐదుగురు ఓకే అన్నారంటే అది 100% ఇంప్లిమెంట్ అవుతుంది.
100%.
మిగతా 193 కంట్రీస్ లో ఐదుగురు ఓకే అన్నారంటే అది ఇంప్లిమెంట్ అవుతుంది.
Yes. There is only the lacking.
Correct. Yeah.
Let me continue, sir.
Yeah, I'll move to conclusion, sir. The United Nations is an indispensable global institution acting as the primary forum for international peace and cooperation under the framework of its charter. The General Assembly serves as the main deliberative body representing the collective voice of all members through its non-binding recommendations. In contrast, the Security Council holds the unique and binding enforcement powers, particularly under Chapter 7, for addressing threats to the to international peace and security. The UN Charter, while upholding the fundamental principle of state sovereignty, non-intervention, also mandates the collective responses to international threats and establishes a hierarchy where member obligations under the Charter override conflicting national laws, Article 103. The structure and its foundational principles underscores the UN's enduring role in navigating complex global challenges and striving for a more peaceful and cooperative world order. So that concludes question number 3. Venu sir, you want to?
Sure.
Venu sir, you want to? Yeah.
Yeah.
10-12 అవుతుంది. ఓకే, we can complete one more. Yes.
ఇంకొకటి చేసి క్లోజ్ చేసేద్దాం సార్. నిర్మలా మేడం గారు చదవకపోతే మనకు అసలు ఇంట్రెస్ట్ ఉండట్లేదు అసలు చదవడానికి.
వెరీ గుడ్.
కరెక్ట్ మేడం, మీరే యు ఆర్ ద కాంపిటెంట్ మేడం.
Correct, but I am traveling, so it might be even worse. My checkered voice would be very irritating. I'm traveling. I'm on the road.
Sorry, madam.
No problem. This is my life, so that's how it is. But even tomorrow, I think I'll be in Hyderabad. So yeah.
సో టీచర్ లేనప్పుడు స్టూడెంట్స్ ఎలా మేనేజ్ చేస్తారో క్లాస్ ను ఈ రోజు అలా మేనేజ్ చేస్తాం.
ఇంకొకటి చదివితే క్లోజ్ చేయొచ్చు హ్యాపీగా. వేణు గారు, మీరు వేణు మాధవ్, డోంట్ ట్రై టు టేక్ ఎన్ ఎక్స్క్యూజ్, జస్ట్ రీడ్ వన్ మోర్.
ఎంత నన్ను స్కూల్ టీచర్ కూడా తెక్కలేదు మేడం. ఓకే, 4th one, air and outer space law. So what are the international legal frameworks, conventions, 5 freedoms, outer space treaty? సో ఈ క్వశ్చన్లు ఏమి అడిగినా మీరు ఇదే ఆన్సర్ రాయండి. 5 ఫ్రీడమ్స్ అని అడుగుతారు, కంగారు పడకండి, దానికి కూడా ఇదే ఆన్సర్. So we'll get back to what is air and outer space law. It constitutes 2 critical and evolving branches of international law. While distinct in their domains, both aim to manage human activities in aerial and celestial realms, ensuring safety, defining sovereignty, and fostering international cooperation and accountability. So ఇప్పుడు ఇంటర్నేషనల్ అయిపోయింది, ఎయిర్ అవుటర్ స్పేస్కి వెళ్ళిపోయాం అనమాట. So international legal framework for air law. Air law governs the use of airspace between national territories by civilian aircraft. Its primary objectives are to ensure the safety of flight attendants, flight operations, upholding the sovereignty of states of their airspace, and facilitate efficient international air transport. So what are the key air conventions? One, Paris Convention. This pioneering treaty of 1919 was a major international agreement to explicitly affirm the complete and exclusive sovereignty of states over its airspace above its territory. It set a fundamental precedent for all subsequent air law. It also leads to creation of International Commission for Air Navigation, which is ICAN, a precursor for ICAO. The second one is Havana Convention 1928, a significant regional air law treaty specifically for the Americans. It is built upon the principles established in Paris, further harmonizing air navigation rules within the Western Hemisphere. The third one is Warsaw Convention, which is 1929, unified rules for international carriage by air, especially regarding carrier liability for passengers, baggage, and cargo. Amended by the Hague Protocol 1955, Montreal Protocols 1975, and Montreal Convention 1999, where in each of them they have done some amendments. The first one is doubled liability limits. The second one, Montreal, with updated currency units to SDRs. The third one is basically modernized and consolidated liability rules. So Montreal Convention 1999 replaced much of the Warsaw system, introduced a two-tier liability system for passengers' injury or death, emphasized carrier obligations and passenger rights in international air travel. So the Chicago Convention 1944, this is a foundational treaty of modern international air law established to contemporary framework for global civil aviation. It led to the creation of International Civil Aviation Organization, ICAO, a specialized agency of United Nations responsible for developing international standards and recommending practices for air navigation, safety, security, and efficiency. Article 1 of the convention definitively recognizes the complete and exclusive sovereignty of states over the airspace above its territory. It establishes a comprehensive set of operational standards for aircraft and air traffic control, ensuring consistent safety and security measures worldwide. Crucially, it introduced the 5 freedoms of air, which are fundamental to commercial air service agreements. So what are these 5 freedoms of the air, which are done in Chicago Convention 1944? They are a set of international commercial aviation rights that allow airlines of one country to enter and operate in another airspace and territory. They are typically granted through bilateral air service agreements. First freedom, transit without landing, the right to fly over a foreign state territory without landing. Example, flight from India to UK, flying over Pakistan or Dubai or some other country. Second freedom, technical stop, the right to land for non-traffic purposes. For example, refueling, maintenance, crew change in a foreign state without picking up or dropping off passengers or cargo. For example, flight from India to US, landing in Germany for refueling. Okay, the third one is third freedom is outbound traffic, the right to disembark passengers and cargo taken on in the home state in a foreign state. This is the third freedom, the right to disembark passengers and cargo onto the home state. Okay. The fourth freedom is inbound traffic, the right to pick passengers and cargo in a foreign state destined for a home state. For example, Air India flying passengers from London back to Hyderabad. Fifth freedom is beyond traffic, the right to transport passengers and cargo within 2 foreign states as part of the service that originates or ends in the home state. This allows an airline to carry traffic between intermediate foreign points. For example, Emirates flying passengers from Dubai to Bangkok and then carrying new passengers from Bangkok to Sydney as part of the same flight. So these are the 5 freedoms. Okay. And then the other one is the legal regime of outer space. The outer space is a specialized body of public international law that governs the activities and states of international aviation, exploration and use of outer space. Its development has been primarily driven by United Nations Committee of Peaceful Use of Outer Space, UNCOPUOS, which drafts and oversees the key treaties. Major outer space treaties and the 5 UN treaties on outer space. One is Outer Space Treaty 1967. This is the foundational character of the international space, often referred to its constitution. It declares outer space is free and exploration and by use by all states, cannot be subject to national appropriation by claim of sovereignty. It mandates the exploration and use of outer space shall be carried out for the benefit and the interest of all countries, which is the charter emphasizing the character as the province of all mankind. It stipulates the use of outer space is limited to peaceful purposes, explicitly banning the placement of weapons of mass destruction in Earth's orbit or celestial bodies. The second one is Rescue Agreement. The treaty creates a strong legal obligations for states to assist astronauts in distress. The third one is Liability Convention 1972. This is a critical treaty establishing a strict liability regime. It indicates that a launching state is absolutely liable for damage caused by its space objects on the surface of the Earth or to the aircraft in the flight. For example, damages caused elsewhere in space. Liability is based on fault. The third one is Registration Convention 1976. The treaty requires launching states to register space objects in national registry and with UN Secretary General. This registration helps identify and track space objects which are crucial for assigning responsibilities and control over liability convention. The fifth one is Moon Agreement. This treaty, while comprehensive, has a low ratification rate, limiting its universal impact. It attempts to declare the moon as a natural resource, moon and its natural resources as the common heritage of mankind, and proposes an international regime to govern the exploitation of its resources, anticipating future resource utilization. So these are the 5 big agreements that are done on outer space. There are 2 relevant cases. One is Cosmos 954 incident, Canada versus USSR. This is the first practical and significant application of liability convention. The Soviet nuclear power satellite Cosmos 954 malfunctioned and re-entered Earth's atmosphere, disintegrating over Canadian territory. This event dispersed highly radioactive debris across vast areas of northern Canada. Canada formally invoked the liability convention, seeking $6 million in damages. After negotiations, USSR paid $3 million to Canada as partial settlement in 1972. Significance: this incident unequally confirmed the principle of strict and absolute liability for damages caused by space objects on Earth. The second one is Trail Smelter Arbitrations, which is USA versus Canada, 1941. Although predating the modern spaces, the landmark arbitration laid foundation ground for the principle of state responsibility for transboundary environmental harm. A smelter owned by Canadian company in Trail, British Columbia, caused significant environmental damage, releasing sulfur dioxide fumes to agriculture and forest lands in the state of Washington, USA. The arbitral tribunal delivered a seminal ruling saying that no state has a right to use or permit the use of territory in such a manner as to cause injury by fumes in a territory of another property. When the case of serious consequence and injury is established, the establishment no harm principle in international environmental law. So what is the relevance is trail smelter principle is a conceptual precursor to the strict liability rules in space law. It reinforces the notion that activities originating in one state jurisdiction must not cause damage to other states and other citizens. So what are the key principles in air and space law? Sovereignty versus res communis. Airspace is sovereign. State possess complete and exclusive authority over their air. Liability: states are held absolutely and strictly liable for damages caused by their space objects on surface of the Earth or to aircraft in a flight, irrespective of fault. The third one, regulation and cooperations. Organizations like ICAO are vital for promoting safe, standard, and efficient aviation. Similarly, UN treaties and UNCOPOS emphasizes peaceful use, international cooperation, and accountability in space activities. So that's what it is. And 5 is peaceful use. The core principle is space law is commitment to peaceful exploration and use of outer space, including the prohibition of weapons of mass destruction. So there ends the question 4. Okay.
Smelter
we-
case మనం ఫస్ట్ ఎన్వైరన్మెంటల్ లాలో చదివాం కదా సార్, ఫస్ట్ సెమిస్టర్ ఐ థింక్.
స్మెల్టర్ కేస్. స్మెల్టర్ కేసే కదా మీరు అనేది. కాస్మోసా? Cosmos is the second one. Cosmos 954 is a very unique case where they were trying to send a satellite with nuclear weapons in it, but it fell down on Canada. And Canada asked for damages based on the Liability Convention 1972. ఇందులో ఏంటంటే సార్, స్పేస్లో 5 freedoms of air ఉంటాయి అండ్ 5 treaties ఉంటాయి సార్.
ట్రీటీస్, యా,
అన్ని 5లే ఇక్కడ. కాస్మోస్ కూడా 954. అది సార్. ఓకే సార్.
ఓకే ఓకే.
థ్యాంక్ యూ.